and welcome to AM 853, all the news, all the time. We begin our program today with discussing the Supreme Court decision that was made this week. Monday afternoon, the case of Arizona State Legislature versus Arizona Independent Redistricting Commission that we discussed a while back was decided. If you missed that episode, here are the main points. The case stemmed from voter approval of an independent commission to draw district lines in 2000. Arizona's Republican legislative leaders filed a lawsuit in 2012 after the commission created a House map that produced 4 safe seats for Republicans, 2 for Democrats, and made the other 3 seats competitive. Democrats won all of the competitive seats in 2012. The Republicans sued, saying that voters did not have the authority to strip elected lawmakers of their power to draw district lines. Gerrymandering has been around for as long as our country has, but this is no ordinary gerrymandering case. The issue here is who gets the power to create district lines. On Monday, the court sided with Arizona's system of having an independent commission redraw congressional districts. But the decision was not made easily. It was 5-4. A large part of the debate over the case hinged on one word: legislature. From the Constitution's clause on elections, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. The two sides argued over whether legislature in the clause can be interpreted to refer to voters who enact the law through ballot initiatives. Paul Clement, the lawyer for Arizona's legislature, said, "The Constitution gave authority over to elections to elected officials, not to the public." Here he is with more of his opinion. Legislature means legislature, and no state vote by the people can divest the legislature of its power to draw congressional districts. The problem is not that somebody else got into the legislature's lane. The problem is that they took an election process away from the legislature entirely, on a permanent basis. State legislatures are elected, politically accountable, and handpicked by the Constitution's authors for the map drawing task. Thanks, Paul. Now we will hear comments from the lawyer for the Redistricting Commission, Seth Waxman. Well, Becca, at the time the Constitution was written, the word legislature meant any lawmaking body created by the people. In Arizona, the Independent Commission, enacted by the people, thus acts as a lawmaking or legislative body. We appreciate your comments, Seth. Wow, they both made some compelling arguments, didn't they? Those justices must have had a difficult time coming to a decision. Let's hear from Justice Ginsburg, who wrote for the majority. The animating principle of our Constitution is that the people themselves are the originating source of all the powers of government. So the Constitution's reference to legislature encompassed the people's legislative power when acting through ballot initiatives. There is no constitutional barrier to a state's empowerment of its people by embracing that form of lawmaking. The people of Arizona turned to the initiative to curb the practice of gerrymandering and, thereby, to ensure that the members of Congress would have a habitual recollection of their dependence on the people. In so acting, Arizona voters sought to restore the core principle of Republican government, namely, that the voters should choose their representatives, not the other way around. The justices who dissented were Roberts, Scalia, Alito, and Thomas. Here's what some of them had to say about the decision. This interpretation is contrary to every other use of the term legislature in the Constitution. One telling example is the 17th Amendment, which revised how senators are chosen. The amendment shifted the decision from state legislatures to the voting booth. The amendment resulted from an arduous, decades-long campaign in which reformers from across the country worked hard to garner approval from Congress in 3/4 of the states. What chumps! Didn't they realize that all they had to do was interpret the constitutional term the legislature to mean the people? If the framers really thought the word legislature meant more than just elected representatives, why didn't they just say that the election rules would be prescribed by each state instead of each state legislatures? At the time the Constitution was adopted, there was no such thing as the referendum or the initiative. So when dictionaries of the time referred to lawmaking power, it was always the legislature and never the people at large. Normally, having arrived at that conclusion, I would express no opinion on the merits. In the present case, however, the majority's resolution of the merits question, legislature means the people, is so outrageously wrong, so utterly devoid of textual or historical support, so flatly in contradiction of prior Supreme Court cases, so obviously the willful product of hostility to redistricting by state legislatures, that I cannot avoid adding my vote to the devastating dissent of the Chief Justice. Well, there you have it. That's how the justices feel. Now let's see how some experts on the matter feel. We are disappointed that the Supreme Court has decided to depart from the clear language of the Constitution. The framers selected the elected representative of the people to conduct congressional redistricting. It's unfortunate that the clear constitutional design has been demolished in Arizona by 5 lawyers at the High Court. The bottom line is that Republicans had no problem with the independent redistricting law when the lines were drawn to their liking. They're having problems in suing to overturn it now that the lines weren't drawn to their liking. And that's frankly not fair, and frankly, not legal. But not everybody disagreed with the court's ruling. The ruling vindicated the rights of voters who want their electoral districts drawn fairly, independently, and without undue emphasis on partisan affiliation or political creed. Hopefully this ruling will bring an end to gerrymandering by letting states create their own nonpartisan district lines. But how it was decided begs the question, is judicial review working in the best interest of our country? I mean, the justices just could not agree. And what they couldn't agree on was what their entire job depends on, the meaning of the Constitution. Should something get passed if so many of the judges aren't in agreement? I'm not so sure. Well, folks, that's all we have time for today. Be sure to join us next week as we bring you all the news, all the time. See ya!